Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who routinely geek out on the channel, one, thank you very much. Number two, we talk about how they will try everything humanly possible to disarm you. It's not just passing laws. It's making it financially impossible. It's making it chronologically impossible. It's making it professionally impossible. Can you imagine a state that has a licensing regime so that if you choose certain professions in which you work out of your home, you are not allowed to be armed in your home? It actually turns your home into a sensitive place. Yes, it's actually happening in America, and there is a challenge to that law that we're going to share with you today. So today, let's spend a few minutes and let's talk about the state that gets to disarm your home. Okay, America, we're going to be talking about a crazy, very oppressive licensing regime from where? That's right, the state of Illinois. The case we're talking about is Miller v. Mueller. Don't try to say that one 5 times real fast. This is a challenge to legislative schemes that are in place in the state of Illinois that governs the licensing of both licensed daycare facilities as well as licensed foster parents. In particular, we're going to be talking about 2 agreements that licensees must sign and must comply with in order to maintain professional licensing. The first is the foster family's firearms agreement. This, of course, is for anyone who wants to be a foster family. The second is the DCFS firearms agreement. Now, let's break it down into 2 categories because there's 2 different types of people here. And I should point out that the plaintiffs here, Miller, are actually licensed to do both, okay? There is licensed daycare facilities, and then there are licensed foster parents. But remember that both of these activities would be taking place inside that individual's home. And when it comes to foster parenting, those activities take place 24/7, 365. Licensed daycares may have business hours of operation. Foster parenting, just like regular parenting, is a 24-hour-a-day job. Now, if you are a licensed daycare facility, you must keep the firearms disassembled, locked away, with the ammunition locked away somewhere else. If you are a licensed foster home, you must keep the firearms locked away at all times. Now, there are Illinois state officials that say, no, that is only during regular business hours. Everything is back to normal when you're not operating normal business hours. But the law does not read that. And as I mentioned, parenting is a 24-hour-a-day job, and if you're foster parenting young children, they might not be away from the home that frequently, which means this turns into a 24/7, 365 designation of your home as a gun-free zone or a sensitive place. Okay, now as a quick side note, I want you to know that the record is very clear that both the Millers have FOID cards. Mr. Miller has a concealed carry license, so there's absolutely no doubt in anybody's mind that they are eligible to possess firearms under both federal and state law. The Second Amendment Foundation, which is bringing this lawsuit in the United States District Court for the Central District of Illinois, also means we'll have a link down below for you to show them some love, is bringing a motion for summary judgment. Summary judgment is where you basically say to the court, listen, just look at the pleadings. The law is so blatantly unconstitutional, you should just award us the win on the pleadings alone. And since we're going to be analyzing the constitutionality of a piece of gun control legislation, we're going to use the Bruin 2-part test, which is, number 1, does the text of the Second Amendment cover the activity? And if so, then we will move on to, is there historical analogs to justify the existence of this gun control law? Well, the activity here is keeping and bearing arms inside one's own home. So yes, the text of the Second Amendment clearly covers it. So now we move over to historical analog. And this is typically where the creative courts, such as the Seventh Circuit, which would be sitting over the top of this, comes up with some fantastic ideas. So when we look at it here, if we look at it this way, there's daycares and there's foster parenting. Is there a historical analog to justify disarming people who are engaged in that activity? No, there isn't. But is the issue really that finite, or is it broader than that? Because isn't the issue really Do we have a historical tradition of disarming individuals inside their own home because of the profession that they have chosen? And this is not about just some type of safe storage provision. This is actually about rendering the firearms completely useless, completely meaningless. They're nothing more than paperweights at this point, simply because of the type of work a person has chose to be engaged in. And despite the fact that the state has clearly come up with all sorts of kind of, sort of close to it, and of course, there is that Supreme Court case out there which constantly pops up in the way of,
you got Rahimi'd.
That really means they don't have to be that close. But ultimately, what Second Amendment Foundation is arguing here is that, hey, listen, you're placing people in this Hobson's choice. The choice being is that you may engage in a profession that you're really good at and very passionate about, or you may get to defend your life and that of your loved ones, but under no circumstances can you do both of them at the same time. As they put it, the defendants instituted rules that force the Millers and every person who fosters children through the state or operates a home daycare facility to choose between fundamental Second Amendment rights and the ability to foster children or operate the home facility. Besides being terrible policy, it is unconstitutional. In light of the above, as the defendants cannot, under Bruin, support their unconstitutional prohibitions and restrictions on foster parents and home daycare licensees, and since plaintiffs have been injured in the stripping away of their Second Amendment rights for nothing more than wanting to take care of children in need, summary judgment in the plaintiff's favor is proper. Okay, we're going to have to carefully watch this case. This is a very righteous argument. The case, once again, is Miller v. Mueller. We're going to link up the motion for summary judgment down below so you can geek out on it for yourself. Remember, links for Second Amendment Foundation down there as well. Now, listen, if you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. But if you don't, it's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. They're saying, you know, what happens is these people get involved in these situations and then they're just denied coverage.
Yeah.
And I think that the model of what some of these companies run, as far as they run like insurance companies,
Yep.
actually leads to that result a little bit.
Yep.
But, you know, that's a fair criticism. People are going to invest money and you're going to be there when it hits the fan, and then it hits the fan and you're not there anymore.
Yeah.
What can Right to Bear say that's going to make them different?
Well, yeah, I think that's a great point. You know, I come from the insurance industry, so I know it well. I know that insurance contracts are written by attorneys for the benefit of the insurance company,
That's
not
right.
the insured.
That's right.
So what we did at Right to Bear is, you know, we're first off, we're gun people that are in the business of supporting gun people. When we started the company, we knew of the numerous other players that had this market pretty captivated at the moment. And after reading their contracts of everybody, we determined that, hey, we can structure an arrangement that gives people, and really the citizens of our country, somebody that's going to be there when they need us most. That was what we prided ourselves on, and I know that sounds like a marketing piece, but it's the truth. That's why we started the business, right?
You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.